Today we, like I told you, we have a special guest. It's who will show up on Zoom at 3 o'clock. Hugo Echeverría is an environmental lawyer who's been very active with rights of nature cases in the Ecuador Supreme Court. And I asked you and put in the readings two cases. And he's going to talk about those cases and more broadly, I think, about what's happening with rights of nature in Ecuador. When we talk of ecological law, this is one of the places where it's actually real. It's actually coming into being. So it's very interesting that way. So we're so fortunate to have Hugo Echeverría with us today. Hugo has worked in environmental law since 2001, focusing on international law and biodiversity conservation, as well as the environmental rule of law. He got his Doctor of Jurisprudence at the Universidade Católica de Quito, had Masters of Law like me, so I was so pleased to know we have this in common. At McGill University, Faculty of Law, we both got our Masters of Law there. And he lectures in law in Ecuador at the undergraduate and graduate level. He's the author of books and essays on constitutional approaches to access to environmental justice. And most important for our topic today, rights of nature, including with regard to marine protected areas. He's a member of the World Commission on Environmental Law, the IUCN, where the Oslo Manifesto came from, as well as a member of the Ecuadorian Foro de Abogados. He's also a collaborator of the Latin American Network of Environmental Public Ministry. He had the wonderful opportunity to live in the Galapagos Islands for 5 years, and I think that's where he developed his passion and also interest in law regarding marine and coastal legal issues from the perspective of world natural heritage sites, enforcement rights, and access to justice. So Hugo's been involved and will talk to us today with interpretation, and I think maybe even you can tell us, Hugo, a development of the constitutional rights for nature in Ecuador's constitution. And so he'll be talking to us about the rights of nature, and in particular, these two recent decisions, which are watershed decisions in terms of the evolving rights of nature movement and jurisprudence. So Hugo, thank you so much for being with us, and we are all ears.
Thank you, and good afternoon to everybody who is taking their time to attend to this conversation. First, I would like to thank Professor Garver and Professor Derani for the invitation, for today's invitation. I have to be honest, I am really glad to be here, to be part of this class for two reasons. First of all, as Professor Garver has pointed out, I did my LLM in McGill back in 2003, 2004, and 2005. And I lived in Montreal, and I enjoyed my time there. I have a very close connection with McGill. I had a really good experience. My master's program was one of my best experiences ever. So to be connected with someone and with people from Montreal and McGill is a joy for me. If you can see in the back, I still have my mug, my McGill mug that is always here in my office. Yes. And secondly, because Professor Derani is one person that has been there for the rights of nature from the very beginning. Her name, I recall her name from way back in 2008, 2009, when no one was talking about rights of nature, she was paying attention from the very beginning to this topic. And of course, I have not been to Florianópolis. I have been to Brazil. I really like visiting Brazil, and I have heard wonderful things about Florianópolis. So I'm glad to be also participating in a class in Florianópolis for the people of Florianópolis. With this, I just have to say I have worked on a little presentation that if it will take around 30 minutes. Is that okay?
Yes, perfect.
Okay, so let me share the screen. Can you see it?
Yes, very well.
Okay, just let me take the chronometer. Well, I want to share the experience of Ecuador regarding the rights of nature. As you know, Ecuador is the first and to date the only country recognizing rights to nature in the constitution. So this happened back in 2008. That is 13 years ago, 13 years ago. And last year was a very important momentum in the development of rights of nature, because the Constitutional Court set the very first rulings on what are these new rights. So the first idea I want to share, and this is like the nuclear idea of the conversation today, is that in only little over a decade, 13 years, this new idea has come to reality, has become a reality. And in a really important way, because the Constitutional Court, the most important court in the country, took over this matter and provided and have provided a very strong content to these new rights. So this is something I want to share with you as a main idea for the entire conversation. There is a country in Latin America that I don't know if the word is appropriate, but that decided to cross the paradigm, to cross the river to the other side of the river, and to include this new idea in the constitution. And only a decade later, we have made it work. And there are many lessons to learn in this process. And I would like to begin with a little introduction in order to explain why Ecuador decided to change paradigms. Well, first of all, as you know, the issue of how to improve the relationship between human beings and the surrounding and nature is a legal topic at the moment. There is a current debate in different legal systems. An example of this is the class that you are taking on ecological approaches to the law. There is, of course, the traditional approach belonging to environmental law. And of course, there are these new approaches of rights, of nature's rights. So this is a topic, this is a debate that lawyers are working on right now, not only in our continent, but elsewhere. Secondly, there are now several models to take a look, including a jurisprudential model, like in Colombia with the Atrato River decision, legislation models like Bolivia, most recently like Panama. Panama just passed a law on rights of nature, and the Ecuadorian model, which is a constitutional model. And this is really interesting for the reasons I will explain later. Chile, as you might know, has included rights of nature in the new draft of their new constitution that will be voted, that will be put for referendum later this year. So Chile is following the constitutional model that was pioneered by Ecuador. Brazil is another example of development on these ideas via jurisprudence. And of course, all these two ideas lead us to conclude that for the past 10, 20 years, there have been the changes regarding to other approaches to the law. The traditional approach to the law is and has been an anthropocentric approach. However, what has happened in the past decade, not only in Ecuador, but in the world, is clearly showing that more and more jurists are thinking about other approaches, including a biocentric approach and the one that we see in Ecuador, that we see in Chile, an ecocentric approach. That has been the case of Ecuador. But often they ask me why. I mean, why making such a radical change? Why addressing these matters from a nature perspective and not from an environmental perspective? There are many reasons to explain this, but in the sake of time, I will only point out to 4 reasons that might give you an idea of what was the context in Ecuador when rights of nature were included in the Constitution. First of all, Ecuador, like some Latin American countries, holds much biodiversity in the country. It is one of 17 mega diverse countries. I think Brazil is in that list as well. So what I'm trying to say is that people living in Ecuador is used to see nature around. We are one of the 8 Amazonian countries. We do have Amazonian ecosystem. We have the Andes, the mountain chain. We have the Pacific Ocean, border with the Pacific Ocean. We have coast, and we also have the Galapagos Islands. So we do have 4 natural regions in a tiny country. And the people is used to live surrounded by mountains, surrounded by the ocean, by the jungle. So nature is an important value to society. And this has come to, as you know, one of the definitions of, or one of the approaches to constitutional law is that the Constitution is simply a reflection of a particular society. It's the reflection of the society. And if we take that approach, that is the case of Ecuador. The environment in the beginning and now nature herself has been a value in the Constitution, not now, not in 2008, way back in the 80s. So this story goes back to at least 40 years, when the Constitution of Ecuador was changed to include the environment as a constitutional issue. Okay, in the 90s, Ecuador moved forward to include biodiversity as a constitutional issue, much like Brazil did. And of course, at the beginning of the 21st century, we moved a little one step forward to include nature as a constitutional value. Third, and this is very important, not the only aspect, but certainly a really important one. Ecuador is a pluralistic society. And and gives a very important normative hierarchy, a very important normative role to indigenous legal system. So it's like in Canada. In Canada, one thing I learned in McGill is that in Canada, the civil law tradition coexists with the common law tradition. And you have a pluralistic approach to the law. In Ecuador, it's the same, but here, the indigenous legal tradition coexists with the civil law tradition. Not, and this coexistence dates back to the 90s, to changes in constitutional law dating back to the 90s. And of course, the idea of rights of nature has a very strong foundation in the indigenous legal system. The concept of Pachamama, for example, is 100% a contribution of the indigenous legal system. Okay. Well, the fourth element I have already explained. Ecuador, like Brazil, and like most of the countries in Latin America, follows the civil law tradition. So we are a civil law tradition country. In 2007, between 2007 and 2008, there was a constitutional convention with the task of drafting a new constitution, a constitution that will set the table to address 21st century challenges, including the relationship between the human being and nature. As I have already said, Ecuador, nature, the environment, has always been a topic when addressing constitutional changes since the 80s. And this time in 2008, there was a question, a very difficult question was raised. And the question was, how effective have been environmental law? How good, how effective has environmental law been in order to confront the ever-growing environmental problems? And to my own sadness, the result was that environmental law, unfortunately, in the case of Ecuador, was not as effective as one would have wished. The effective results were actually really poor, because since the 80s, we have had legislation, we have an institutional framework set, we have an environmental authority, we have several regulations, and yet we have had we still have many environmental problems, much worse than the ones that we had in the 80s. Pollution, oil exploitation, use of chemicals in agriculture, damages of mangroves due to expansion of shrimp farming, agro-industry, and a long list of examples. And the problem with environmental legislation, I'm not saying environmental law as legal discipline, but environmental legislation and regulation in Ecuador was never able to put nature first. When addressing environmental challenges from a sustainable development perspective, the economy always won the argument, and in the environment and society always came in second and third place. And somehow that was validated, that was approved by the standards provided by the environmental laws in Ecuador. So you have huge projects that we all knew that they were going to have problems with the environmental impact. Nevertheless, the state will issue authorizations. So instead, those environmental licenses were, in some cases, became licenses to pollute, licenses to create an environmental harm, and that was not good. So at the Constitutional Convention, they decided that that something needed to change, and the change came from this idea of recognizing rights to nature, not seeing nature or putting nature not as an object of protection anymore, but a subject of rights, a rights holder. And of course, in this dialogue, the concept of the indigenous concept of Pachamama was very successful, because Pachamama means Mother Earth. I mean, it doesn't mean something to protect. It means somebody to respect. And this change is not semantic. It has deep, substantial, material consequences, as the Constitutional Court has acknowledged in the very first verdicts issued last year. And last but not least, as you all know, when you access the wonderful world of constitutional law, you have access to beautiful constitutional remedies, like the amparo. I don't know what is the name in Brazil, but basically this constitutional tool that all the countries now have, designed to go to court on constitutional grounds and get a fast remedy from the court. So we are not, when we talked about rights of nature in Ecuador, we are not talking about administrative law. We are not talking about environmental law, that, to be honest, no one really pays attention to it. But we are talking about constitutional law and constitutional procedural law. So this is wonderful, and this is why the court has, some of these cases have reached to the Constitutional Court of Ecuador, and this is why we are now having the court providing content to these new rights. Before I continue, and I know that the questions are left for the end, but is it okay? Are you able to listen to me? Okay, is my accent understandable?
It's perfect. Yes, it's really great. Yeah.
Okay, I'm trying to talk slow or slower in order to make myself clear. All right. Well, this slide is just to like to summarize what we have spoken in the past 15 minutes. In Ecuador, nature is a new subject of rights. It's a rights holder. It's not an object anymore. It's like you and me. It's a subject of rights. The Constitution and the court have acknowledged that those rights include respect of the existence of nature. The second right is resilience, that is maintenance of vital cycles, maintenance of natural functions, and the structure of nature. And the third right is that in case of harm to ecosystems, the right of nature to be restored. So all the money does not go to the people, but that it goes to invest in restoration projects. And as you can see in the slide, the reference to nature is not as an it anymore, because it's not an object. The reference to nature is as a she or as her, because she is Mother Nature, she is Pachamama. Again, this is not semantics. This is a qualitative difference between the environmental approach of the environment as something to protect versus the ecocentric approach of nature as someone to respect. So the value is different. And this is why the court has translated this change into a very simple concept. The concept is that because Ecuador has recognized rights to nature, the standards to respect nature have to be higher, have to be better, stronger than the standards provided by environmental law. And this is not theory. This is the reason behind some of the decisions taken by the court in cases regarding the constitutional review of legislation. In order, so just a minute to go to move from legal framework to institutional framework. The Constitutional Court. What is the Constitutional Court? This court is the highest body of constitutional control, interpretation, and justice in Ecuador. If you like, it is like the Supreme Court, but only for constitutional matters. Okay, and the court is integrated by 9 judges, all of them experts in constitutional law and human rights law. Okay, so this is why what I like about this, because the development of rights of nature in Ecuador was not a political development, didn't go to the legislative power. It should have gone, yes, because we are a civil law tradition country, but it never. But legislators didn't provided legal content to these new rights. Okay. Instead, these cases went to the court, and now we have jurisprudence. We have jurisprudential development of these new rights. It's like a common law tradition being worked in order to provide content to rights of nature in a civil law tradition country. This is in itself is an interesting phenomenon. So if you ask me, I am really glad because the ones who have addressed rights of nature are judges who are experts on constitutional law. So in the decisions, you don't see politics there. You see law. And this is really a very strong value behind this jurisprudence, this very first jurisprudence on rights of nature. Okay. What powers does the Constitutional Court has? What can the court do? The court can do regarding the rights of nature has 2 powers, very important ones. The first one is constitutional review. So the court can check, can review whether or not a law meets constitutional standard in any matter, not only nature or environment, but in any matter, in any constitutional topic. So the court can check whether or not a given law or regulation or ordinance is in accordance with the Constitution. And the second power, this is even more interesting, is that the court ex officio by itself, the court can select cases any matter of any constitutional topic in order to set precedent, to issue decisions with erga omnes effect in order to provide constitutional content to constitutional rights. So in a way, it's a bit like it has this power is a bit like a legislator, and it's a controversial power, without a doubt. But it is a power the court has, and this court has used it in order to give society a response on what are rights of nature. How are these rights different from environmental rights, and how do these new rights relate with human rights? Okay, so the rights of nature were chosen by the Constitutional Court of Ecuador since 2019 as part of an effort of the court to give answers to society on very sensitive matters. So this Constitutional Court which is in office since 2018 decided to address difficult topics that were pending and that were important to society, namely topics on gender, topics, for example, on the always controversial issue of abortion, and of course, the new rights of nature. So what I'm trying to say is that what has happened with jurisprudence in Ecuador is part of a bigger context in which the Constitutional Court has played a very important role, not only addressing these new rights, but other topics of social relevance. This how do you say, cuadro, this slide is designed to show you the difference, from the most obvious difference that when we address this matter from environmental law, we addressed it from the human being perspective. I protect nature because it is important for me, because I see nature as a resource and I want to keep it there, to use it sustainable, to keep having resources for the next generations. And that's good. And that's not bad. The concept of sustainable development is not bad at all. But when you address the topic as from nature, and this is what the court have said, you value nature beyond the use, beyond the concept of natural resource. So there is a difference there. And the difference is that you do not protect the environment, but you respect nature. The value, the standard goes up. Okay? Because you are not protecting something, but you are respecting the rights of a new legal subject. And if you go to the indigenous legal tradition, you know that Mother Earth, Mother is in the top hierarchy of society, is the mother. I mean, is the most respected person in the community. It's not the father, it's not the son, it's not the cousin or uncle, it's the mother. So that's very important. And of course, and this is most important, this is not environmental law. When we talk about rights of nature in Ecuador, at least, we are not talking about environmental law. We are talking about constitutional law. And I'm telling you this for experience because I am an environmental lawyer, as I prepared myself to become an environmental lawyer, but now for the past 5 years, I have switched to constitutional law. I have been studying a lot of constitutional law because this is not environmental law anymore. This is not administrative law. This is constitutional law. And I have to say, I'm very happy with the transition because constitutional law is just wonderful. I will say it's even better than environmental law. And that's why some of my environmental law colleagues do not really like that statement. But that's the truth. Constitutional law is really nice. Okay, now you see that the Constitutional Court has been very serious about these new rights of nature. And it has been so serious that have selected cases that are really, really complex. You have to be crazy to address topics like this in a country like Ecuador. I don't know if you know, but Ecuador, unfortunately, has become, historically, has been heavily dependent on oil exploitation, with terrible examples and experiences like the Chevron case. But now the country is flirting with mining and with industrial mining. But the problem is that how do you mine in in a very high biodiversity areas? You guys have in Brazil, you have this terrible experience of, I think it's Santa Marianita, right? So we are all traumatized by that. And nevertheless, the executive power is heavily promoting, inviting mining companies to the country. But the court is stopping that. We also have, the court have also chosen selecting cases on hydropower plants. The problem with that is that the hydropower plants reduce or divert the natural flow of the river. And the reduction is so critical that in summer, those rivers get dry, completely dry. So that's not good. And third, the problem with habitat loss for endangered species. So none of these cases are simple, not only from a juridical perspective, but also from an economic perspective. Okay, and yet the court, I must say, valiantly, very bravely, have selected these complicated cases to give an answer on what are the rights of nature. I have to say, there's another complication on this. All these cases are not about illegal activities. All these cases are about projects, including transnational projects with legal authorization, with environmental license, with license to get water, with all the permits and all the stamps that the state can provide. So you see, the challenge was not against any administrative law, but the challenge was rights of nature versus environmental laws. Okay. There are to date 6 cases already ruled, decided by the court. But in the sake of, I just want to ask, I have 30 minutes in my chronometer. Can I take 5 more minutes?
We are feel so fortunate to have this time with you. We will have whatever time you can give us, Hugo. This is really terrific. So take whatever time you need.
Okay, thank you very much, Geoff. And I don't want to bore you. I just want to make sure that we do have time, because as you see, what has happened in Ecuador is very interesting, and some detail I wanted to share with this experience with some detail in order to you to get a very good picture of this. There have been 6 cases ruled since 2000, last year, basically, since the June 2021 to February 2022. So the past 6 months have been really busy and important for the rights of nature. So I will like to make a reference to 2 cases. Los CEDROS case, and this is a case that was known by, for some reason, it became very popular outside of Ecuador. And this is a case regarding the prevention of the extinction of endangered species. Okay? The threat to endangered species came from a mining project which was operating with a state authorization. And the second case is about constitutional review, is regarding an environmental law, a new environmental law that was included a provision on what activities can be authorized in mangrove areas. Okay, so these two cases are really interesting, and I would like to take some time to address these cases. Los Cedros case is about mining in a place that is a forest, a protected forest. So there is this alliance of a Canadian company with an Ecuadorian company, very powerful companies, both of them. They wanted to explore for minerals, copper, in an area that is very high on biodiversity, and it has been classified since the 80s as protected forest. Okay, so you can imagine this area it has a very high rate of biodiversity. However, this area is only in quoting only a protected forest. Is not a natural protected area. It's not a national park or anything like that. And therefore, what the Constitution says is that mining is prohibited, should not be authorized in protected areas, meaning national parks and other categories. But given that this area, Los Cedros is the name, was not a protected area, but a protected forest, the state of Ecuador issued authorization to these two companies to start exploring for minerals. Because the activity was only exploration and not yet exploitation, the environmental requirements were very, very low. According to Ecuadorian environmental law, exploration is considered as an activity of low environmental impact, not even medium, but low. And in accordance to that, the environmental requirements are also very, very low. However, this case went to court because it happens that in Los Cedros, Los Cedros holds the habitat of some 100 and plus protected species of flora and fauna, including the critically, and listen to this, including the critically endangered spider monkey. In the forest, in that particular forest, the last census on this specific species counted for 200 monkeys, 200 individuals. So when the case went to court, the question was not whether or not Los Cedros was or wasn't a protected area or a protected forest. That was irrelevant. That is administrative law. What it was relevant is that how can the state of Ecuador authorize a mining project in the habitat of critically endangered species? How can environmental law authorize such an idea? Okay. So you see the difference. When the case went to court, the topic of whether or not the area is a protected a national park or a protected forest became absolutely irrelevant, and the conversation changed towards whether or not it is possible to authorize a mining project in the habitat of critically endangered species. Okay? And of course, you see the difference. Whereas environmental law is has this standard of authorizing this activity, the constitutional rights of nature has a higher standard of restricting such activity. Why is this? Because Article 73 of the Constitution includes this provision that gives a practical effect to the recognition of rights of nature. I will invite you to read because this provision is really nice. As you see, the constitutional standard on right of nature is not authorizing anything that comes to the state, but to be very careful to avoid extinction of species. And this is a mandate. The Constitution uses the verb shall. Is not at discretion of the environmental authority, but it is an obligation. And this is why the court actually decided to revoke the permits issued by the state to these companies. The court said, I know that, to the companies, I know that you met all the environmental standards and that is good, but those standards are not good enough to prevent the extinction of a species. And therefore, the error was in the state, because the state should have never had authorized such a project, because it put at risk precaution and prevention species that are already critically endangered. So as you see, the rights of nature in this particular case clearly shows that environmental standards are not good enough. This is incredible. I mean, I have to acknowledge that as an environmental lawyer, this is quite incredible. The quality, the change is qualitative, is substantial. What it is legal to environmental laws is not necessarily meeting constitutional standards. And this is with Los CEDROS case. As you see, the focus on the case was the species and habitat. So ecosystem and species. In the mangroves case, there was a different approach. This is a constitutional review of the new environmental law. In 2018, 10 years later, 10 years after the Constitution passed, Ecuador approved a new environmental law. The new environmental law was supposed to be in accordance with the Constitution. Okay. However, in order to benefit a very powerful economic sector of Ecuador, which is the shrimp farming industry. You know what shrimp farming is, Camarón? Yeah. Okay.
Yes. Yeah.
This is a industry, I think, is number 3 in revenue to the country, after oil and banana. So these guys are very important, and they want to expand their operations to areas that are close to the sea, because they need the water from the sea. But in those areas, we do have an important this wonderful ecosystem of manglar. The Constitution includes a provision declaring the mangroves another ecosystem and some other ecosystems, such as the Amazonian ecosystem, as fragile ecosystems, requiring a special protection, additional protection. But contradicting or in contradiction with the Constitution, the legislator approved this environmental law, setting a very ambiguous provision on what activities should be authorized in mangrove areas. So the text, the content of the provision was so ambiguous, so vague, that could be interpreted either way. Okay? So an environmental group, an NGO, see the role of civil society, very important, was decided to challenge that specific provision of the law on the grounds of rights of nature. So they went to the court, to the Constitutional Court, and asked for the court to conduct a constitutional review on the mangroves provision of the new environmental law of Ecuador. So the court took this case very seriously. It called for a hearing. Many parties appeared in the hearing, including myself. It was really a very important professional experience, because you were able to have these discussions at the constitutional level, very high level, very interesting. And the court relied on what the Constitution said. The court said that mangroves are fragile ecosystems, and therefore they need to have a special protection, additional protection. The court decided to address the case not from an environmental law perspective, but from a constitutional rights of nature perspective. And in that avenue, the court decided, using the legal principle, the principle of legality. The court said something that is very obvious to constitutional lawyers, that laws shall be in accordance with constitutional provisions. And also what we call in Spanish legal security. That means that any law, that provisions shall be clear, detailed, and precise. That legislation cannot be ambiguous or vague. Okay? So you see, this is not new. This is the ideas that any constitutional lawyer is familiar with anywhere in the world. Well, what the court said is that, first of all, mangroves, and this is an ecocentric foundation, 100%. Mangroves are right holders under constitutional law. They are not simply natural resources, but mangroves themselves are right holders. The second point, and this is criticism to sustainable development. You see, very diplomatically, the court says, sustainable development is a very nice idea in the classroom, but in practice is not really good. The court said that mangroves have become fragile ecosystem due to unsustainable use. So they are not in themselves fragile. In fact, mangroves are very strong trees, but due to unsustainable use, they have become fragile. And of course, that mangroves require a special protection. And the conclusion of the case was that this provision was expelled out, was taken out from the legal framework of Ecuador on charges of ambiguity and vagueness. The court reached to the conclusion that the constitutional standard of legal security was not met by this specific provision of the environmental law. It was so vaguely written that anybody will be able to interpret it in such a way that shrimp farming will be authorized in mangrove areas. Okay? So as of now, the shrimp farmers are not able to attack the mangroves anymore because rights of nature were able to stop that intention of expanding their agro industry to this beautiful and fragile ecosystem. Look the paragraph, and this is incredible. The concurrent vote and even the dissenting vote reached to the same conclusion, an ecocentric verdict, that mangroves are by themselves ecosystems with constitutional rights. You can read in the concurrent vote. And even in the dissenting vote, mangroves are to be constitutionally protected due to their intrinsic value. This is incredible. I mean, I don't know about, I get excited because I have never read such decisions, not at least in Ecuador, that a judge who is not, who is a judge, I mean, is a constitutional attorney, acknowledging that an ecocentric approach can coexist in the law is beyond my imagination. It's very good. And to conclude, the future is challenging, but it's certainly optimistic. I have to say, because I want to be as honest as possible, rights of nature are not welcomed by everybody. Even though there are recognized in the Constitution, and even though we do now have these decisions to share and to analyze and to study, it does not mean that everybody likes rights of nature. The debate on whether or not nature could be a new subject of rights is still ongoing in Ecuador. Even environmental lawyers resent this idea, because to environmental lawyers, they think that with a better application of environmental law, we could reach to the same conclusion. So I just wanted to let you know that rights of nature are under attack at the moment. And the attack is very heavy because from the mining sector, they are able to hire the best constitutional attorneys that Ecuador can offer. And of course, their arguments are really good arguments. But yet again, that also provides or gets the effect that the dialogue and the controversy on rights of nature is it's a controversy with very high standards in law. Because on the side of the miners, on the side of the stream farmers, of the oil exporters, etc., their lawyers provide with really good arguments that really makes the advocates of rights of nature and the court, think hard about how to better apply the constitutional rights of nature in Ecuador. The second conclusion, very important. This is not environmental law, I insist. This is not anthropocentric paradigm. This is ecocentric paradigm belonging to constitutional law. And this is what you are also watching in countries like Chile. It is good because I don't know about Brazil, I don't know about Canada, but in Ecuador, the reality, you have to remember, I am also a practicing lawyer, and the reality is that not very many take environmental laws very seriously, especially at corporation levels. Labor law is more important, tax law is more important, property law is almost sacred, and environmental law, well, okay, let's take a look. So if you put nature in the Constitution, it becomes a constitutional matter that everybody respects. Okay? Fair, and as a consequence of this, you know what? I'm not saying that Ecuador has become the Garden of Eden. Far from it. We do have many problems regarding the environment and nature. But I can clearly conclude that the role, law is better placed. There is a more effective role of the law in trying to set limits in the relationship human and nature. This is a good idea. Anything getting closer to ecological approaches is good idea to get a better scenario for a relationship between the human being and nature. And finally, I am happy to see that other countries are following this trend. And not only Andean countries or countries belonging to indigenous legal traditions, but other countries like Panama, Chile, and certainly even in other continents. So my conclusion is that rights of nature, my guess is that they have come to stay. And that's it. And sorry for taking so much time, 45 minutes. Thank you.
Wow, what an amazing 45 minutes, Hugo. So thank you so much. I have all kinds of reactions, but I want to open it up to the class here who have been listening very attentively. So are there any questions from any of you for Hugo? And you can either come up here and ask them, or you can say them in the anything. Maybe I can get started. I have some questions. Would you? Amaya Carlos, Andres, why don't you go ahead?
Well, thanks so much. Since we were already in the spot, then probably it's kind of the appropriate thing. Hugo, thanks so much. Muchísimas gracias. Actually, we are from Ecuador, and we are, as a matter of fact, in University of Vermont. We both are part of the Gandhi Institute for the Environment. So awesome that this invitation was also extended to us. So such a great opportunity to listen to you. I do have a question, and I don't know if that is because I missed slightly the part when you were talking about Los Cedros, but I had somebody knocking at my door, so I went to open the door and I missed exactly that part. But when I saw the sentence that was given of that case, it seems to me that it is not binding. But you were saying that decisions made the constitutional level set the precedents, like provide the contents for the rest of the law. So how can that be? That's something that I don't understand.
Thank you, Carlos Andres. Nice to meet you. I went to Vermont 2 years, no, before the pandemic, and I had a really good experience there. In order to, but I went visiting for an event. So saludos to Carlos Andres and Amaya. Okay, to give an answer, any case selected by the Constitutional Court has the legal effect of deciding not only the case itself, but also setting precedent. Okay, so this is the what the Constitutional Procedural Law of Ecuador, the new one, provides as an outcome of this power of the court in selecting cases. In the specific case of Los Cedros, the court selected the case not only to give an answer to the parties, but also to give an answer to what are constitutional rights. Okay, so that's the answer. This is something that goes beyond Los Cedros case, that goes beyond rights of nature, and applies to any decision that the Constitutional Court adopts in a case that is selected by the court itself. This is really interesting, and I understand your question, because we were not used to such power of the court. We are a civil law tradition. We are used to seeing the judges as the mouth of the law, la boca de la ley, only with powers only of application of the law, of the civil code, etc. But no, the new constitution, adopting these standards of the common law system, this includes this new power to the court. I also have to say, this is not an invention from Ecuador. This is actually a copy from the Constitution of Colombia. The Colombia and the Constitutional Court of Colombia has exactly the same power, and actually we copied from them. This power of the court to interpret the Constitution and using specific cases to as a setting to produce binding jurisprudence. If I might say, of course, this new power is not absent of controversy. I always like to be honest in this. Many lawyers think that this is giving a quasi-legislative power to the court. And there is an ongoing debate right now in Ecuador on whether or not the judges are able to, I mean, whether or not this is a conflict with division of powers. But so far, this is a debate, and the court is using that power not only to on rights of nature, but in other complicated topics.
So I want to ask my question and then we'll turn to Cristiane because I think it follows on there. So you didn't know this, but before class, we were talking about different actors and also about how, well, you might know Capra and Matei's book, The Ecology of Law, talking about mechanistic law that where the current approach to law gives strong powers to the state and private interests working together and treating nature, of course, as an object and not a subject of rights typically. So Ecuador, among other reasons, is very interesting because this constitutional right of nature is created through a political process, but then it gives this role, which is very important to the court, to the judges. And we were talking about how, well, courts say they don't go picking their topics, the topics come to them through the process of litigation and contests among people. But it's interesting to note in both of these cases, you have the arguments of the legislature, you have the arguments of the government, you have the arguments of the government, the procurators, the prosecutors, I guess, who are all on the side of the development interests, who are defending the development law for the mangroves or who are defending the mining concessions in the case of Los CEDROS. So, and yet those constitutional provisions apply to them as well. So I just wondered if you want to maybe it's a little what you were saying, but if you want to comment a little more about that dynamic.
Thank you. Yes. Okay. First of all, one thing that comes out to mind is that the judges have become perhaps the most important actors. And this is really interesting because the judges are the least, I mean, when you talked about environmental matters, you think about the Ministry of Environment, you think about the legislator, but you never think about the judge. So this is a phenomenon in itself. Second, but this is of course like a Russian roulette. This is, if you have a bad court, then you have problems. If you have, you need a good court, independent court, like the one we have now in Ecuador. That was not the case in the past. That was not the case in the past. But if you have a good court, not in terms of environmentally friendly, but a court that is serious about law enforcement, who is serious about the rule of law, then you have a certain degree of security that your issue will be duly addressed, will be okay. And this is really important. Look, you know, many people advocating for rights of nature, which I must say, I am not an advocate for rights of nature. I'm just a lawyer that see rights of nature as an important tool to protect nature, to respect nature. But people who are activists on rights of nature, they were actually concerned about the court deciding on rights of nature. Because if you take a look of the integration of the court, this court is rather conservative. Is not, I mean, is not, or if generally speaking, is a blend of several ideologies, and none of them, or most of them, were not familiar with environmental law, let alone with rights of nature. Okay, and at least one of them was against the protection of the environment. So I can understand my colleagues, and advocates of rights of nature, they were concerned and worried about how the court will react to this topic. On the contrary, I was always happy for this specific court to address this topic, precisely because this court represents different approaches to the law. And what you see in the decision is exactly that. The court is not saying that Ecuador is close to development. The court is not saying that we have to stop breeding in order to prevent extinction of a species or something like that. What the court is saying is that because rights of nature are constitutional rights, they need to be developed in accordance to constitutional standards. The court is not saying that mining is forbidden in Ecuador. What the court is saying that mining is forbidden in certain areas where nature is more important than mining. Okay, so you see an effort of the court trying to set a balance. Even in the last case, which recognized rights to animals, rights to non-human animals, a case regarding the habeas corpus in favor of a primate, of a monkey. The court was careful enough to say that under the rights of nature, animals as part of nature are also rights holders. But the court also said that does not mean that humans shall stop eating meat. Or, so the court was trying to set a due balance among different perspectives. So that's what I have to say regarding that. And finally, you see a tension. There is a tension between the Constitutional Court as the body in charge of making constitutional control with the executive power, because the executive power is all about development because it needs income, especially now that we are all coming out of the pandemic. So we need the money, and the government is just, anything that gets money, welcome. So, and I have to say, in countries like Ecuador, I don't know how it's in Brazil, but in countries like Ecuador, there is a history of not respect to independence of power. The judicial system has always been very close to the executive power. So this is right now is different, and the court is actually saying no to the executive power. And of course, the executive power is not very happy with that. But at the end of the day, the decisions of the court are being enforced.
Yeah, it's fascinating. I mean, it's really amazing decisions. Cristiane, do you want to?
Close your microphone and then.
Or you can come from. It's easier because I have to close my microphone. I have to close my sound, so it's better just to use the one.
Hi, thank you very, very much for your tremendous presentation. We have so much to learn and so much to compare, and it's an inspiration, really an inspiration. Talking about that, you set up a very interesting topic related to the theoretical things, a theoretical issue, which is that rights of nature is not related to environmental law, but it's related to constitutional law. It's part of constitutional law. This is a very important statement in my view, because it supports an idea of change. of a real, so what, so we started talking about what constitution is and what for it is, and then you talk about rights of nature is a constitutional topic. Well, I would like to hear a little bit more about this in terms of what do you think, considering this? How do you think about the change we can promote in terms of the relationship between human society and the nature, and what is well, why it is, because formally speaking in Ecuador you can say, oh, it's constitutional because it's stated in the constitution, but this is also a question. Is that the reason why you say that the rights of nature is a constitutional issue because it is formally in the constitution, or we could consider it a conceptual and material thing and say that the rights of nature is a constitutional topic because of the content of these rights? So that's the
Thank you.
question.
Excellent question, Professor. The answer is the second alternative. It is a material change. Why? Because if what the court has said is that the constitutional rights of nature should be addressed from in the context of principle and rules of constitutional law. And this is why you see the rule of law as a foundation. You see the principle of legal security, you see the principle of legality. The judges are saying anything that has to do with rights of nature has to be legislated, not being regulated by the Ministry of Environment, but has to be legislated. Why? Because these are constitutional rights. And just like any other right, it is the task of the legislator to develop, not the ministry, not the minister or the president. Secondly, and this is more important, the court says that the environmental law standards fell into the category of administrative law. And basically, these standards are bureaucracy. I mean, you have to fill out a form and then you get the permit, and that's it. It's administrative law logic. But the court says that is not the case with rights of nature, because these rights belong to the constitutional world, where you need more than the court says mero trámite, a mere or a simple procedure. You need to provide content to any decision. For example, in the case of los CEDROS, the state defended, the defense of the state was that because Los Cedros is not a protected area, they were under the obligation to provide the environmental authorization. That's it. But the court replied back and said, but you have to pay attention that whether or not is a protected area, this is the habitat of endangered species. I mean, and you have to give content to your decision. And because this is constitutional law, you have to be serious about it. It's not about putting a stamp in a paper. It's about actually doing an assessment from a perspective of the endangered species themselves, not from the perspective of the company, the mining company, or not even from the perspective of the state. The perspective changes from the humans to the species. And last but not least, the court also clarified that the fact that autonomy is given to rights of nature, it does not mean that it collides with environmental rights. This is very important. The court actually acknowledges a complementary approach. Why? Because the Constitution of Ecuador sets the standard that all constitutional rights are of equal significance, and they shall be applied in as much as uniformity as possible. So this concept that is largely applied among human rights, for example, the right to life and the right of health, or the right of labor and the right of property. With these new decisions, the court has extended this idea of complementary approach to human rights and rights of nature. And just to conclude, let's remember that what we have here are the very first decisions on rights of nature. These are really good and have provided so many elements to share and to analyze. But this is only 6 decisions. So many topics are yet to be addressed in the years to come.
Muchas gracias.
Yeah, it's such an exciting time. Do you have a little more time, Hugo?
Yes, I do.
So I just want to, I don't, you may have seen this blog post, Verfassungsblog. It's interpreting the recent decisions, especially the Los CEDROS case. Do you know about this? By Gustavo Prieto?
Yeah.
So, and he talks about how the court treated the idea of precaution. And you had the one dissenting judge who said, well, you got it all wrong. You were actually applying a principle of prevention, not precaution. But his interpretation, and I wanted to hear what you have to say, is that this is such a strict interpretation of precaution that it's very difficult to see what kinds of activities, and maybe it's in certain areas, or, you know, based on what you said, could be allowed under this interpretation of you know, taking a restrictive and precautionary approach. So I was wondering if you could comment on that particular aspect of it, because it seems very interesting. And it's really in connection, just to wrap this up, this big question. So what is allowed now? So the court says, we're not stopping everything, but what are they stopping and what are they not stopping?
Okay, this is actually a really nice topic because given that the difference between prevention and precaution was not clear in this decision, if you compare it with a previous decision where the principle of precaution was perfectly drafted by the court, this has been taken advantage by the mining lawyers. They actually just won a case at first level court because they were able to show that because of this confusion, the standard on prevention and precaution should not be considered as precedent, okay, because there is a dissenting vote. So they were able to win a case using that argument that everything is precedent except the standard on precaution and prevention. As you see, this reflects a heavy controversy in Ecuador on what is precaution and what is prevention. The way I see the way I read the decision of the court is that the court really didn't want to make a difference in this particular case. In other cases, it did, but didn't want to make a difference between precaution or prevention. What the court focused was on if you know that there are species that are critically endangered. I mean, that's a fact. That's something that is scientifically proven. And then the state is obligated to adopt a decision with precaution, with a higher standard of care. Okay, not really about whether or not what are the effects of mining. You see the difference? It was not about whether or not mining, what will be the effects of mining, but it was about that they were concerned about the species themselves. And they knew, I mean, and in my conclusion is that they favored the approach of prevention because they knew that those species were critically endangered. And of course, mining activity is not a good idea in their habitat. As you see, my opinion is somehow you have two lawyers and three opinions. And my opinion is the third one. I acknowledge that. But I think because I have been studying very deeply this, I was able to speak with some of the judges about this, and they later on, they are not judges anymore. They left the court, and that's, you know, their focus was not in the mining itself, but on the protection of the species.
So
And
then that seems then to be consistent with what you were saying before, that this really, the balance, this idea of all of the rights protected in the Constitution being at the equal level means how they will be interpreted together is really going to depend on where it happens and how it happens. So it's going to be different in a forest like this that has species of special concern than maybe someplace else, or you know, maybe a similar idea with coastal areas or mangroves. Like what exactly would get
exactly. This is, and the court says later on, the court issued and what we call auto de aclaración. It means a second or complementary argumentation, because the miners asked the court to make additional comments on certain elements of the decision, and the court actually said that this will be set case by case. Every case will be different. And another thing that is important, this decision should not be read, or any of the decisions of the court regarding rights of nature should not be read as against mining or in favor of nature. What the court did, and the court says that in this complementary verdict, says that they simply applied Article 73 of the Constitution. Regardless of nature or the mining, what the Constitution says is that the state shall be cautious when trying to regulate activities that might threaten a species with extinction. So the scenario that says the Constitution is a radical scenario, I mean an extreme scenario of extinction. And because of that, the standard of the Constitution is also very extreme, is restricting activities. And the standard is not even prevention, is precaution. I mean, you have to be extra cautious in that way, no? So that's why I think the court, again, the court pay attention not to the effects of the project, which indeed are not very of high impact because it's only exploration, but to what will happen with the species. And if you see, the court says that the prohibition is not only about mining, but about any other activity that might create an impact in their habitat.
Very interesting. So my last question is, you said you're not considering yourself an environmental lawyer, but more a constitutional lawyer. Would you consider yourself an ecological lawyer?
Yes, I do. Look, my foundation has always been. I have always felt comfortable, even before these rights of nature, with the idea of going beyond the concept of sustainable development in practice. I have to look. It's important for you to know that I am an attorney. I'm not 100% a professor, and I like to see how theory reacts in practice. And Ecuador is such a wonderful study case for that. So I have always felt comfortable with the idea of greening the law. And now I have made myself, I have transitioned from administrative law, even from criminal law, because my background is on criminal law, to constitutional law. And to be honest, in the past 5 years, of course, I learned constitutional law in the university, but I never practiced constitutional law. And now I am doing it, and I really like. I think is in countries like Ecuador, where they have taken constitutional law to the highest level with the new constitution. It's important. Constitutional law today is the most important area of law.
Well, it's certainly fascinating to hear your perspective. It's a very, very interesting time to be in a position like you are. And again, we feel so fortunate. Let me check in with the class if there's any questions that have come to mind. Yeah?
Thank you. Thank you, Professor.
Do you want to come? Can you come up here? Maybe you can sit there and he can probably hear it from there. Okay.
It's okay. Hello, Professor. My name is Marcia. I'm a student here in the Master of the University of Santa Catarina. And thank you for your speech. It was really inspirational. But I think I have some doubts similar to Professor Derani, and it was not clear for me about this constitutional approach about environmental and rights of the nature. As here in Brazil, these rights of nature, they are not set forth in our constitution. Yes. And do you think it's possible to say that there is a constitutional right that that maybe it's based on a common sense and like a global ecological constitution? Like there's or it's maybe part of the doctrine, or we could use it in litigation. Because here in Brazil and in Florianópolis, we had an experience that is being conducted by the University of Florianópolis with Professor Morato. And there's a group that filed a class action in order to protect the Lagoa da Conceição. However, it was not made, they need a kind of association to do that. It was not in the name of the nature, but it was, how can I say, filed by this association. Through this association, and I think that it's really interesting because we need to protect this ecosystem that is very important here to our city, but in some ways we have this difficulty here in our constitution that doesn't establish this right for their own.
Excellent. Thank you, Marcia. And thank you very much, because your question will allow me to address a topic that I didn't, and it is very important. If you take a look of what is happening in the entire continent, you are clearly seeing that there is an effort to make environmental law greener. Okay, and there is actually the judge Lorenzetti talks about two currents, two different avenues. One of them is rights of nature, and the other one is what they call the greening of environmental law or the environmental rule of law. And all the Brazilian constitution and the entire continent, the constitutions in different countries, they are ecological constitutions. I mean, if you ask me, they are biocentric constitutions, because they do set, they are concerned about not only the environment because of the, from the environmental quality, but also from the point of ecological equilibrium. Okay, so all the constitutions, Colombian constitution, that's why they call it as the ecological constitution, the Brazilian constitution, all the Peru, Venezuela, all the countries have this greening element of environmental law. So what the effort of Professor Morato, which I am familiar with, the case of Laguna de Consensao, and also the efforts of other scholars and judges in Brazil, the case of Suiza, the case of the parrot, clearly shows that in countries like Brazil, they are trying to using the current constitution to expand to these new areas. Okay, not necessarily from the rights of nature perspective, but from this other avenue of greening of environmental law. If you ask me, I think that rights of nature will remain as an alternative trend, accepted only in countries that have opening up to this trend or current, as Judge Lorenzetti said. The majority of countries will go to the other avenue, which is more famous at the moment, is more welcome. This greening of environmental law, among other reasons, because you don't need to change paradigms. You can still stay in the context of anthropocentric environmental law, and all you need is to make it better, to actually point out to what sustainable development aims, which is protecting the environment. And just to conclude, I think, and this is why my environmental law colleagues have delete me from Facebook, because I think, look, the way I see this is that the rights of nature are the new kid on the new kids on the block. Is the unwelcome neighbor that came to show the weaknesses of environmental law. And of course, no one liked to show, no one feel comfortable to show the weaknesses. So I guess if you ask me, the reason why environmental law now is debating on how to become more effective and how to reach the goals of sustainable development is because unwelcome new kids like rights of nature and these ecological approaches to the law in more general. So even if rights of nature disappear from theory and practice, they have already achieved a very important role, which is to shake a sleepy environmental law, trying to make it more effective. And I love that. I really do. Because I, for one, have been quite frustrated with the poor level of effectiveness of environmental law, at least in my country. And now things are changing thanks to this new approach.
Very interesting. Are there any other? Yes. Yeah. One more question, Hugo, if you have time.
Yes, of course.
Hi, Professor. Nice to meet you. My name is Victoria. I am a student of master class here too. And it's amazing pleasure watching you. And my question, please take my notes. Okay. Sorry. My English is not so good, but I hear I studied some things that you explaining today for us, and I think that it's an important step, this recognition that of rights of nature in constitutions, and there's no doubt that there are impressive arguments on these decisions, but I have some doubts about the effectiveness of these decisions, because in Latin America, we have some difficulty to turn these decisions a reality. And I want to know what you think about this, and what these decisions bring to us, to ways to implement these steps, and what do you think about this? Thank you so much.
Thank you, Victoria. Excellent question, and congratulations. You have a really good group of master students in Florianópolis. I might go there to study my master's in constitutional law, which I plan to do in this or the next year, either in McGill or in Florianópolis. Okay, effectiveness has always been the weak point of, I mean, everybody acknowledges that environmental law is very weak in terms of effectiveness everywhere. And example, you have a leading case in Latin America, which is the Argentinian very famous case of the Matanza Riachuelo, the river. 10 years later, this case was ruled in 2008, more like over 10 years later, the ruling has been accomplished only in 40%. Only 40% of the cleaning up of the river has been conducted. And we can name many other decisions. In Ecuador, the Chevron case is still in court for everybody died already, and the case is still in court, etc., etc., etc. So, of course, we don't want that to happen with rights of nature. And in fact, the ones opposing to rights of nature are really working hard to make sure that the decisions are not become effective. That's one of the strategies, for example, because they know that if rights of nature fall in the same weakness as environmental law, it will be the end of rights of nature. However, the court acknowledged that reality, and well, in the cases of constitutional review, the effectiveness is immediate. Those provisions that were contrary to the rights of nature are out of the system now. They are not valid anymore. So the effect was immediate in these cases. In the cases regarding selection of cases, the court not only declared violation of rights of nature, but also ordered, and this is also controversial from the court, ordered the legislative power to approve new legislation, okay? And ordered the executive power to approve new regulation. And the court also set a date. It gave a year of time, not months, I mean, a reasonable date for the executive and the legislative power to sit down and work. Of course, the legislative power and the executive power are not happy with that, and they claim that the court is stepping into their territory, and they don't like that. But the court replied back saying, look, if you don't do your job, I will do it for you. So I'm trying to be respectful with the division of powers, and I'm telling you that you have to do this. You have to change the law, because otherwise my decision will not be effective. And I'm not playing with this, and I'm giving you a year. And if you don't do that in a year, then we have a legal tool that is called acción de incumplimiento. If the public authority does not meet with constitutional court orders, then anybody can sue in this case, the executive of the legislative power. So you see, the court makes sure that to avoid any route that will make their decisions in rights of nature matters become ineffective. So if you invite me in a year from now, I will tell you what happens, what happened with all these decisions. But just to give you an idea, in the case in the animal rights case, the court ordered the ombudsman office to draft a new regulation on rights of animals. And the ombudsman office is immediately sitting down and working on the draft. And I know this because I invited to be part of the commission that will providing inputs for purposes of drafting these new regulations. So what I'm trying to say is that whatever the court says, the authorities are meeting, are accepting and reluctantly accepting, but they are doing their work.
Well, they do seem like really significant decisions. I suppose, you know, I mean, there will be no mines under these rules in that forest. And it looks pretty doubtful for shrimp farming in those mangrove areas too. That seems effective. But like you said, you know, then you have the power interests that they could change the Constitution if the pressure built to a certain extent. So that's all, you know, while we were talking earlier today about how power is a factor here, how the different pieces that make up a legal system are always evolving. They're all interdependent and they're moving together with the overarching questions of power and the rights of, you know, this is the concern I had because I've seen it with other kinds of rights. They get diluted because of how power interests shifts, or sometimes they get strengthened. So it was so great to have you here, Hugo, talking about where things stand right now, especially after these constitutional cases, very significant constitutional cases that are coming down, have come down, and I guess will continue to come down. Thank you so much for your generous time and a really interesting session with us today.
Before I go, I would like just to say a comment on your last reflection, which is also shared by me.
Please.
Look, rights of nature have become so powerful, so fast, that no one expected. It's like a punch coming out of nowhere to the powerful people. And I have no doubt, I really do, that in the next Constitutional Convention of Ecuador, rights of nature will be a contentious matter. And this is why I am, from a personal perspective, I am preparing from right now to that specific battle. And it is important, who knows what will happen in the next Constitutional Convention of Ecuador. So it's important to be ready for that attack. And one of the strategies in order to counter, you know, to defend rights of nature as constitutional rights is to make sure that these rights are blended into, become jurisprudence. That's one thing. And second, are replicated in other countries, just like it's happening in Chile. And third, are welcomed by the doctrine, are not regarded as something weird anymore or something strange. So this is important because if the next Constitution of Ecuador or the Constitutional Convention dare to take these rights out, we have the tool to, you know, we have the progression principle to defend ourselves. So yes, you are right, Geoff, anything can happen now and something will happen because this development of the case of Ecuador has created a lot of, there is many people upset about this, and people with power.
Yeah.
From my end, I just want to say thank you. I insist, I am so glad that I am very happy for your invitation. It was nice to see you. It was nice to share this time with you. And I hope it is the first, but not the last.
Me too. I look forward to meeting you someday in person, Hugo. Thank you again so much.
Certainly. Muchas gracias. Espero poder verte aqui, invitado por nós outros aqui no programa de pós-grado de la Universidad Federal de Santa Catarina. Muchas gracias. Es un
Muchas
honor
gracias.
tenerlo aquí.
Hasta luego,
Thank you
Cristiane.
very
Ciao,
much.
Joe. Thank you very much and goodbye. Good afternoon.
Bye-bye.